Thank you so much for coming to our breakout session on sort of cross-border investigations, ethical issues, and government cooperation, among other things. The world is getting smaller and smaller every day, it seems, and for any company doing business and cross-borders, the risks that come with complying with the different laws and regulations and in the various jurisdictions has become increasingly complex, and of course the stakes for getting it right or for not getting it right are becoming higher and higher. In the U.S., we have an increasingly robust Department of Justice when it comes to looking at international conduct that's reaching deeper and deeper into its investigative toolkit. We learned this morning from the Wall Street Journal, actually, that DOJ is using FARIA, the banking statute that arose out of the savings and loans scandal, to investigate Volkswagen on its emissions issue. So that's getting more and more complex. And at the same time, DOJ, of course, is demanding that companies adopt an all-or-nothing approach when it comes to granting credit for cooperation in their investigations. In the Eurozone and the UK, you have also increasingly muscular regulators and law enforcement that is often putting US-based companies under an investigative microscope. And increasingly, in this sort of global investigative arena, there's more and more focus on the compliance regimes. In the UK this week, for example, you have the FCA announcing that they're going to be holding individual corporate officers individually liable for compliance failures at their individual companies. And Department of Justice, of course, very recently hired its own in-house compliance expert, both to look at companies both during their investigations to see and evaluate the status of their compliance framework, and also to evaluate the effectiveness and the seriousness that they adopt mitigating measures in response to the investigations. Of course, this global arena raises an array of issues. How does a company stay in front of misconduct by using cutting-edge compliance tools from preventing that misconduct from happening in the first place? When investigation commences, what's the best approach, especially when it comes to cooperation? How does one navigate potentially conflicting laws and still meet that measure and that standard of being deemed cooperative? What happens at the end of an investigation? Make sure that any potential misconduct doesn't happen again, particularly when you're dealing with a global organization. So to address some of these issues, and I hope we can get to all of them in our allotted time frame, we have a remarkable panel that is assembled of experts and in-house experts that deal with these issues on a day-to-day basis, and we're all fortunate and very thankful to be moderating a panel amongst them. To my left, we have David Howard, who is Corporate Vice President, Deputy General Counsel of Microsoft Corporation, where he leads their litigation competition law and compliance team. He's in charge of all litigation inside the U.S. and all the major litigation outside the U.S., and is responsible for engagement with antitrust regulators worldwide, and heads legal compliance, which includes compliance investigations. He has more than 25 years of litigation experience, spanning work in the White House as an assistant United States attorney and as a partner at Gov't, where he co-chaired the firm's white collars and securities litigation group. He's an experienced trial and appellate lawyer and serves on the board of trustees of the Lawyers Committee for Civil Rights under Law. He is a Princeton University undergrad and a fellow Quaker Penn graduate from the University of Pennsylvania Law School and clerked in the Eastern District of Pennsylvania. To his left is Kristen Ludgate, the Vice President, Associate General Counsel, and Chief Compliance Officer of 3M, and also serves as the chair of the 3M Business Conduct Committee. She leads 3M's global compliance organization with responsibility for compliance, programming, training, business conduct investigations, evaluations, assessments, and, of course, the international compliance operations and counseling. Prior to her role as Chief Compliance Officer, Kristen was 3M's Chief Employment Counsel and has been a member of the senior leadership teams at 3M's Legal Affairs and Human Resources and responsibility for significant investigation, litigation, and compliant matters throughout her 3M career. She also began in private practice in Minneapolis and has also served as the general counsel for a private university in St. Paul, and is a summa cum laude graduate of both Bowdoin College in Maine and the University of Minnesota Law School. And finally, we have Cora Neff, who's the Senior Vice President and Corporate Compliance Officer for Wyndham Worldwide, where she's responsible for managing the compliance, ethics, information management, and privacy programs across the global hospitality company. Prior to the spinoff that created Wyndham Worldwide, Corin served as litigation counsel for Sendon Corporation, and earlier in her career, she worked in private practice focusing on general commercial litigation. She graduated with a BA from Emory in Atlanta and received her JD from the American University Washington College in Washington, D.C. And we'll talk a little bit about D.C. as we go on. We're going to skip opening statements, I think, because of our limited time period, and get sort of right to the meat of our presentation. And I think I want to start sort of before an investigation happens. And David, talked a little bit before that there's sort of many new and developing challenges global, worldwide when it comes to compliance and investigations. What are some of the new things that multinational companies like Microsoft are doing to mitigate the risks, to sort of get in front of a cross-border investigation before it even happens?
So I guess what I would do is focus on a couple of things that we're thinking a lot about these days. The first one, in some ways, is kind of, I think, the new frontier in compliance, and perhaps something that really has the potential to move the dial in a very significant way, and that's the use of big data. I noticed that there's a session later in the conference about big data that focuses on the risks associated with that, and those risks are obviously very real. But when you think about it from a compliance perspective, the ability to marshal the investigation that companies have on hand in order to predict, for instance, what transactions are worthy of further scrutiny, or even what roles in the company and what geographies in those roles are the most likely to offer certain other types of compliance problems, and then train and monitor to that information, was really huge. So we're working right now on trying to, frankly, come up with a couple of pilots that would help us identify transactions that could be problematic from either a sales deal execution, channel stuffing perspective, or from an anti-corruption perspective. And that's, I think, something that's going to be incredibly helpful as we move forward. And you can see how it will get more sophisticated as time goes by. So right now we're focusing on those factors that we know are probably going to contribute to those things. Ultimately, we'll probably get data scientists involved who can tell us what other factors nobody's thinking about that actually contribute to compliance violations in those areas. So that's the first thing I would just note as, potentially the golden ticket in this area. The other thing is more cultural, and that's something we're doing a lot of thinking about, which is how do we talk about compliance. I've been in this role. I took some time off from the compliance world when I joined the company and just was doing litigation and antitrust, but I've been in this role now for about a year. And as I get more deeply involved in it and think about it, one of the things that occurs to me is that the more we talk about compliance, in some ways, the worse off we are. That really what we really need to do is to talk about these issues as a business imperative and as important to the success of the company. So we're working right now on developing narratives that we can use and training materials that we can use to talk about compliance and talk about reporting violations, really as an integral part of the business and as tied specifically to what we've identified as the mission of Microsoft and the essential values of the Microsoft that are going to help us succeed as a company.
When it comes, two really interesting points, I think. When it comes to sort of using big data, particularly when you're dealing with a large multinational company like Microsoft, are there concerns that come into play about the impact of local privacy laws that might limit the scope of a big data project, or are those things that can be navigated around when doing a company-wide project, like you mentioned?
Yeah, sure. I think that certain types of, there are going to be certain limitations on what we can do in certain areas. But on the other hand, to the extent that we're mining company data about sales, company data about credit term extensions, those types of systems, there really should be no limitations in how we deal with those.
And of course, I think the issue of culture and sort of getting compliance of not being a burden that's imposed upon employees, but an investment to a more profitable business. that is sort of, I think, front and center for any company. Chris and Corey, do you have thoughts on sort of the new developments and sort of how do one approaches these issues?
Well, so I think I agree on big data, and I think many compliance organizations, and I'm sure many of you are trying to figure this out. It intuitively makes a lot of sense that we sit on all this data, that we ought to be able to make better use of it. I always get a little concerned on the flip side. My business clients are looking for the magic answer where we don't have to do investigations anymore. And I don't think, and I think you heard that on the general counsel panel this morning, you're never going to have a perfect company, but if you can really use it to focus your efforts and focus your programs. We're doing the same thing in terms of how we talk about compliance as a business advantage, as a competitive advantage for our company in an era where people want to trust their partners. They want to do business with companies they trust. So it's an interesting, I mean, one of the most interesting things about this job, I think, is the prevention side, but you're toggling back and forth all the time with the investigation side, and how do you create those feedback loops. And I guess that would be the third thing that we're really looking at is your investigations. You learn a lot from those. How do you make sure that you build processes that don't just tell you who's collecting the email and who's going to impose a discipline, but how you're feeding back your lessons learned and getting that information out. So those would be some things we're working on just now.
So Karen, you get to go third. Oh, it's always great to go third on a question because all the good things are usually said. But anything to add?
So I'll tell you a bit about Wyndham's approach. It combines a lot of what David had indicated with respect to taking data and then also combining it with the culture of ethics. And what we've done, and probably because we don't have the benefit of being a technology company with the Microsoft resources, is we've actually done this through in-person rolling risk assessments. So we take the key top 80 leaders or so within an organization and use internal audit to really sit down with those leaders on a quarterly basis and plot the risks on a heat map to be able to determine what is the high risk, high impact areas of the organization. Then based upon that, we might be able to take deeper dives into areas where we would do data analytics on certain areas based upon the risk profile. But aside from it helping us to identify risk, we've found that the real tangible benefit is actually sitting and having the dialogue with leaders, making them think about risk issues, and then figuring out ultimately how they would remedy those risks or mitigate them.
So let's say despite all of our best efforts, there's a need for an investigation. A fact comes in from one of your international locations that triggers the need for an investigation. Kristen, when you sort of first get that notice of a possible need of an investigation internationally, how do you decide how to proceed? And in particular, when something happens overseas, sort of how do you balance your resource requirements and also maybe the cultural issues in deciding how much of the investigation is going to draw on your U.S.-based resources and how much to rely on sort of locally based resources?
And so 3M, I'm sure like many of you, were highly matrixed, which makes for long answers to questions like this. So I'll try to not get tangled in the weeds too much. And I think I would say when you think about global versus local, I think for us it's almost always global and local. It's some combination of perspectives and resources, and where that line gets drawn is what we're looking at. So for us, and this is one we're assuming that we know about the issue, there's the second issue of things that come up locally or handled locally and you never hear about them. But assuming it's come to us, and we're the triage function in the company, we have investigators in compliance, but we also work with investigators in audit and HR and corporate security. Our first cut is not global versus local. It's what kind of issue is it and what function seems has the best capability to look at the core. Now, of course, your ability to tell that from a report is better or worse, depending on what's come in. But we take that functional approach first. That lets us look at all the issues, first of all. So we're sure that there's nothing coming in that maybe looked like one thing, but we know it relates to another thing. And then we get it to whoever the lead investigator is. And each function will make its own call about how they work with their headquarters team versus their teams, in our international group. But I think even in the most local of local matters, so if it's an HR matter and it's going to be handled in the country by an HR person, they're still going to come back to us and tell us what happened. So we have a monitoring function, and we're still there to help them if they need resources. If they need to pull emails and they don't have the capability to do that, we can figure out how to do that for them, either with a local, retained resources, or if data privacy laws allow, we can do it from the center. So it's, even there's a global lens on it, but it's going to be locally driven. The flip side, say it's one that we really say, oh, this could have a government enforcement angle to it. And the investigators on my team are lawyers with law enforcement, FBI background. They can do those investigations that may need to be able to be credible in a disclosure posture or something. But they're still going to need to be informed very much by country resources, right? So, and then it's going to be, is it ours or is it going to be outside? Are we going to need to go retain our own because we need to protect the local business, create a firewall around that business so they're not really involved at all in the investigation? Or can we draw on our local legal team, for example, to understand a little bit about the local enforcement climate in addition to whatever may be going on in the U.S., in addition to cultural issues we may need to know about, if we need a local law firm. So we're always going to have that piece. The last thing we think about is language, and language is a tough one. If you're in a big company and you're in 100 countries, you can't have someone on staff for every language. I think by and large in our larger subsidiaries, English is the language of business, and by and large we're able to use our English-speaking investigators most of the time for investigations in those locations. In others, we really have to think about how big an issue is language, and does that tip in favor of a local resource under our supervision, even if it's in the middle, or does it mean we're going to retain? So there are all those overlays, and then there's the legal issue around who could pull data, what are the data privacy requirements, and what other local legal requirements do we need to know about? For example, under local labor laws, are there procedures for how we have to operate with employees? We have a works council agreement in Europe that that may govern how we approach employees. So it's for us, it's not an easy issue. I think now we've been doing it long enough, we pretty well know the questions to ask, but I wouldn't say we have a one-size-fits-all answer.
So it sounds like a lot of it is dependent on getting that information out of the local entity to the home office, which it sounds like you have procedures in place and that. Well, Cora, my understanding is Wyndham is a little bit more decentralized in its compliance approach. So how does it work for your company?
So it's very similar in nature. We have so the way Wyndham works is we have corporate services, and then we have 3 business units. So each business unit general counsel acts as the compliance officer of the business unit. But in corporate services, what we've tried to do is similar to what Kristen outlined, really put together a framework by which each one of those business unit general counsels can operate. And in terms of matters that we deem to be significant, so financial reporting issues or things of that nature, those escalate up to corporate services, so we can make a determination as to how those matters should be handled. I think just extending a bit in terms of what Kristen said, and a lot of this is you understand the facts and who should investigate it as they come in. But we've found that really helping to set expectations with the business has been very beneficial, so it doesn't look as though we're taking what might seem to be a scattershot approach as to whether corporate should be handling an investigation or whether a local office should be handling an investigation. So we actually put together a manual that we provide to all people who are able to do investigations, who we've kind of authorized to do investigations, so they know, if we're pulling an investigation from them, there's really a good reason as to why, and they'll start to learn to expect that.
Corin, this is our Global Ethics Summit, so I have to have at least one question that has the word ethics in it. So let's say our investigation has the decision is made to commence the investigation. The decision is made of how to staff it as far as using local resources versus home office resources. What are some of the ethical issues that arise from a company participating in an international investigation? And what are some of the ways to deal with those issues? Very broad question, so I apologize.
No, that's so I think the foundation is in culture. So really ensuring that your senior leadership has an understanding that sometimes you might have a rotten apple in an organization, and also that actual investigations are a good thing. Nobody wants to be subject to a government inquiry, but knowing that these things are percolating up really should be a mark of your program working. So having that basic understanding from leadership is really important. I think the next thing has to do with transparency, and it becomes a really tricky topic when you're overseas because the privacy laws really varying. So in some jurisdictions, the U.S., for example, if there's an investigation, you can be completely transparent with all levels of leadership, confidentially, of course, as to what's happening and what's going on with an investigation. In Europe, for example, if you're investigating an individual, there might be some real strict parameters about who you can bring into that investigation. In some instances, you might not be able to be transparent with your local management team there. So those decisions around transparency can be very ethically driven. And then once it's transparency within the organization and that's resolved, it's also ensuring that there's transparency to the board. That's certainly very important. And then also how an organization is going to deal with an investigation that may result in a finding that there was something that went awry, whether it's just HR in nature or an employee relations related, or whether it's something having to do with fraud or greater misconduct. And to what degree do you not let a good crisis go to waste, and you let your broader employee base know what's happening and the consequences on a de-identified basis, and to what extent you communicate it to stakeholders if you have customers that it may impact or business partners that it may impact.
That's a related question really for any of you to step in is, a lot of what we're seeing, and I mentioned in my sort of opening comments, in the UK, there's an emphasis on really going after individual executives when there's a compliance failure that arises out of an investigation. In the U.S., we have the Yates memo, which was recently issued by the Department of Justice, which very, squarely says in very unambiguous terms that cooperation essentially means that companies helping to identify culpable individuals during investigations. And we've seen a number of settlements recently where companies have agreed to part ways with employees. And I guess, so the question is, a company has an ethical obligation, obviously, to stand by its employees when they've done nothing wrong. But there's also this increased pressure from governmental resources to, I don't want to use the word scapegoat, but to serve a head up on a platter occasionally. And so I was just wondering how from an ethical perspective, how you deal with that balance of commitment to your employees and being fair to them, but also balancing the demands of ever more aggressive regulators across the world.
So I think it's a fascinating question. I guess I'd begin by saying that I may be in the vast minority on this, but in my view, the Yates memo is not really a sea change at all. From my perspective, if you're going to cooperate with the government, you're going to cooperate with the government, and that includes identifying people who have done things that are inappropriate. And frankly, from a company's perspective, if you've determined that somebody has done something inappropriate, then you want that person out of the company, and it may not be a terrible thing to have that person prosecuted, because that sends a very, very powerful message to the rest of your employee population that if you cheat, something worse can happen to you than just quitting or getting fired and finding a job somewhere else. So I'm completely aligned with the government on that aspect of it. I think the more difficult issues arise when you take into consideration that I think despite the fact that we have an obligation to identify people who have done something wrong and to make disclosures and deal in a very clear way with people who transgress, we also have a duty of fundamental fairness to all of our employees. And where I get a little bit troubled is where governments make requests of us that are inconsistent with what I consider that duty of fundamental fairness. So, for instance, from my perspective, and I think from the company's perspective, if the government wants to talk to somebody, they ought to be represented by counsel. And that may not necessarily be something that the government really wants. But I do believe if you have to take a long-term view of these issues, and from our perspective, the long-term view is that we have to, cooperate with the government and help them identify people who have really done something wrong. But at the same time, we can't act in a way that is fundamentally unfair to our employees, because and that's probably true of the guilty ones and also the not guilty ones. So that is an area, and I think there are other areas where there is that inconsistency and misalignment sometimes between the interests of the government and the interests of the company, and it's an area where I think there could really be some benefit to some further dialogue with the government on those types of issues.
So you mentioned representation by counsel, and of course, not too far from here in the Southern District of New York, not so long ago, actually when I was still an assistant United States attorney there, Judge Kaplan issued the Stein decision, U.S. v. Stein, where he essentially found that the government violated the due process rights of defendants by inappropriately pressuring KPMG not to pay their attorney's fees, and sort of getting to the heart of the right to be represented by counsel. And for the flaws, the definite flaws that we have in the system when it comes to due process in the United States, it's different. It can be different overseas. So the question is like, have you seen or are you aware of sort of significant types of due process differences in Europe or in Asia or in the Eurozone when it comes to how matters are investigated by the government, what the company's rights are, what individuals' rights are that differ from the United States?
Well, I think that the answer to that is, different companies have different systems. Different countries, rather, have different systems. And, I think it's a mistake, for U.S. companies that operate globally to believe that they're not going to have to abide by those systems when they're doing business in those places. I mean, it's just a fundamental, there's a certain arrogance in believing that, the U.S. law should apply even when you're operating in Korea or Tanzania or in any of the 150 countries in which Microsoft operates. We do have to live by those rules, and we need to respect them and respect the fact that they may have slightly different systems and systems that don't recognize some of the protections that we offer. I do think that there are some fundamental due process aspects that have been mostly recognized for the most part, I think, so far in the antitrust area, but that really ought to apply globally. And when I think about that, I think of a few things. I mean, one is the right to be represented by effective counsel, and counsel of your choice. That's sort of fundamental. The right to understand the specifics of what somebody thinks you've done wrong is pretty fundamental. The third one that I would identify is the right to have an opportunity to state your case, both on the law and the facts, to an administrative body. The fourth one I would identify is, I think it's fundamental to have a right to appeal to some sort of neutral tribunal, whether it's a court or some sort of administrative tribunal. And the fifth one, and I think it's really interesting when you think about it, but I think it ought to be fundamental, is countries oughtn't ask you to do something that violates the laws of another country in which you operate. And that's one, I think, where we're going to see a lot of focus in the next few years, for instance, in the privacy area. And, if any of you have had the opportunity, I'd recommend to you the book that Justice Breyer just wrote called The Court and the World, where he spends a lot of time talking about how the Supreme Court these days has to consider what the regimes are and what the laws are of other nations, and more than ever before try to not just make sure that you're not acting inconsistently with those regimes, but actually try to harmonize the laws. And so I think that's an area where we're going to see increased focus in the next few years, and one that I think is pretty fundamental.
I think one of those areas where there has been that tension, not experienced by the companies on this panel, but that I've seen in my practice and have heard a lot about, is in the area of data protection, and in particular in Europe, for example, as well as Asia, which has some strict data protection laws that limit the ability to bring documents with the names of individuals or information about individuals over to the United States without violating those individual data protection laws. This has been invoked by companies and their counsels in global investigations, the Department of Justice, and in in a speech that was given, again, not too far from here, down at my alma mater, NYU School of Law, the head of the Criminal Division Department of Justice pointed it out and actually said companies should be on notice that the blanket assertion of not being able to produce documents from Europe because of data protection laws, that basically Department of Justice wasn't going to hear that, and that companies should approach international investigations, I believe the terms is with the premise of how am I going to help Department of Justice, not how I'm going to find reasons not to help, was basically as she put it. Kristen, just turning to you, is how do companies navigate the potential, I'm not saying it's an actual tension, but the potential tension that David identifies, and in particular in the data protection space, where you have on the one hand companies' obvious obligation to comply with local laws, but on the other hand threatening the sort of existential threat of an indictment from the Department of Justice if it deems that the company's not been cooperative by relying on those local laws to not produce certain information.
So I'll say, and maybe, I don't know how popular my answer will be, but I sort of agree with the Department of Justice when they say, don't just come to me with a whole bunch of reasons why you can't do it, come to me with solutions. And I think the whole premise of this is you're in a cooperation posture, and how you got there, whether you got there because you chose to make the phone call, and we heard about that this morning, about sometimes the benefit of if you called them, you're going to get a different dialogue going, maybe, than if they called you. But nonetheless, if you're in a cooperation posture, you're cooperating. And I am not and I know we have privacy experts on the panel, so what I'll tell you as a non-privacy expert is it seems to me that you often don't have agreement on what the laws require. You often can find creative ways to do investigations that aren't solely reliable on consent to search individual emails, for example, a common issue that you hear about. So I think you'd approach it as you would any other issue when you're trying to cooperate, which is you would be credible and you'd be transparent. You would be sure that you knew what you were doing as you were looking into it. So if you don't have the internal capability, you would have gotten some help, and you would go in and say, here's what we've done, and here's what we found, and here's where we're finding a stumbling block. Here's how we're trying to get around it. And I think you should think about the fact if you say, well, we just can't do that in France, you may be inviting a phone call from the Department of Justice here to French authorities, right? So I actually sort of agree. I understand that the quote from that speech can be troubling taken out of context, but I guess my experience wouldn't be that you're going to sit in the room and someone is going to say, we don't care what the law is, we want you to violate the law. I don't think that any of us should take that as the message. I think we should be real clear on the fact, though, we also shouldn't try to wear that as a shield. And probably we all need to make sure we have access to good expertise on data privacy. And as a non-expert, I would say that's becoming more and more important to me in my day-to-day job working on investigations. So I know you're a privacy person. I think you guys both probably have more privacy experience than I do on the details of how that works. But that would be the spirit in which I would approach that issue.
So in other words, as an advocate to convince the Department of Justice that you really are doing everything that you can and finding creative ways to meet their demands and convince them that you really are in a cooperative and not resorting, as was suggested in the speech, that companies might do to use it as a giant shield. Well,
and not just as an advocate, because I also want to know what happened, right? And this is, we all need to remember at the end of the day, you can get dialogues going with governments that aren't as constructive as you wish. But fundamentally, we all want good, transparent business relationships, fair business relationships. We're all on the same side of not wanting corrupt business environments. And so, I think it's not just what they would want, it's what I would want, right? We're always looking for figuring out how we can get to the bottom of what happened. And then, of course, yes, we're going to advocate for the company's position, but we're also going to do that knowing that, if we made a mistake, we want to fix it and we want to know what happened.
And what I would say is there's no magic bullet and to this dilemma. I mean, it is a dilemma. It's a conflicts of law analysis a lot of times, but I think that there are things that organizations can do to ready themselves, and it's not going to be the perfect answer for every jurisdiction. But if you're contemplating putting a privacy notice out to your employees talking about privacy practices, include in there that you might be providing information to governmental entities to the extent that there is an investigation. It's about awareness, and it's about building some of these things in. If you're worried about cross-border data transfer issues, make sure you have model contracts or binding corporate rules or this new privacy shield that's been put in place. So it doesn't necessarily mean that you need to wait for the regulator to come knocking. There are a lot of things that you can do proactively. And again, that's not going to answer all of your problems, but it's going to at least get you part of the way there.
So I think we've identified a couple of areas in which there is potential tension between the interests of the company and the interests of the Department of Justice when carrying out an investigation. What about when the government prioritizes its investigation over your internal investigation? Does it happen where the government will ask you to stand down or not look at certain information or look at certain documents? And how does a company deal with that, Cora?
I think it's really about, again, going back to the transparency and openness point before. I mean, I think that governments, just like companies, aren't looking generally to be unreasonable. So if you can start to foster a dialogue to understand why the government wants you to stand down if there's a period of time, and you can start to explain to the government what your concerns are. If there is really, I feel that our roles are to protect the shareholders' interests. So if you feel that your shareholders' interest is going to be compromised by not pursuing an investigation, I think the government would want to understand that. So I think really that openness can oftentimes bridge the gap.
I would just echo that in the sense that, as I said, I think that in most situations, the interests of the government and the interests of a company that actually cares about compliance are really aligned. And I identified one of them a few minutes ago, where in terms of our need to be sensitive to and fair to our employees, whether innocent or guilty, is an area where there is probably a lack of alignment at times. But I think this is another area where there is a little bit of a potential clash. And another area where I think further discussions with the government about this sort of thing would really be enormously helpful, which is to say, we do have an obligation to our shareholders. And if we think something has happened in a bad place, something bad has happened in a particular place, whether it be in the United States or in another country, then our job and our obligation to our shareholders is to try to stem the damage and to make sure it doesn't happen again, and to do that as quickly as possible. And if the government were to say, no, we want to do our own investigation, and we don't want you to terminate anybody, and we don't want you to continue your internal investigation, and that were to go on for a considerable period of time, I do think that there's a misalignment in terms of the interests of the government and the interests of the company there. And that's an area where I think we could really benefit from having mature discussions with the government about those types of things.
And I think that what also arises is the tensions between different governments, where you have two countries conducting an investigation over similar conduct and are pushing for different results. I won't ask you guys to comment on that unless you want to. But if not, since I know we're supposed to leave a certain number of time for questions, but I do want to ask one final question for each of you, and it touches on a point that you made earlier, David, about the importance of installing the right culture, and maybe not using the word compliance, but having it as a business investment. And I guess the question of sort of the two cultural questions, right? One is that having a corporate-wide culture that values compliance and views it as an investment and as a way to a path forward for a business to become more profitable. And then there's the other cultural issues that you operate in countries that have very, very different cultures. And so the question, which might be the toughest question, is how do you translate the first cultural values of a culture of compliance across many, many different cultures along the multinational areas that each of your companies operate. So it's a tough question, but I'll ask each of you to just give a thought before we turn it over to questions. So Corinne, you were the third person I asked a question, so I'll ask you first on this one. It's okay.
So I think we all know that there needs to be a strong tone from the top, and that's really important to be able to translate across cultures. And then also, when you talk about tone from the top, it means the top of an organization, but the top of an organization within each of the geographic areas in which an organization operates. But I found, for me personally, what's been the most valuable way to transcend cultures, and we were talking about this a bit before the panel started, is actually going out and visiting locations. And I'll tell you, I was traveling to one of our offices, and I was doing a speaking engagement. So I had just made left turn to visit the office, and the head of that office didn't know I would be there, and he saw me and his face dropped, and he said, "Take me away." And we joked about it, and it became a really good lesson as to who we are and what we're trying to promote as compliance. And it's, again, compliance is the evil word, but how do you get people to understand that we're really all shooting towards the same goal, and being able to understand what will drive compliance, or ethics within that particular region, and how you can not just speak to the language of the company, but speak to the language of the local people. Another story was I was in Denmark and doing a little bit of FCPA training, and I pulled up the list that shows where every company is on the corruption index, and they said, "Look at us, look at you. Why are you telling me about corruption? You're in America. We're far superior to you." So, but just explaining to them the context of, you guys do a great job. Maybe there's things we can learn from you in terms of your culture and how you operate, and then bring that back to us in the United States and headquarters to kind of spread that message out. So I think really just the face-to-face interaction is the most important thing.
Kristen, do you have thoughts sort of?
Yeah, so I agree with all of that, and I'm always amazed when I travel, and particularly when you're traveling not because of an investigation, you're really just traveling to see how your teams are doing and meet all the business leaders, and people are really happy to have us there, which is important, because when you do have a problem, then you encourage this, pick up the phone, and we're here to help, and I think that's part of it. But other thing, we worry about the transmission of our culture. 3M's been around for 113 years, but as we get more dispersed and our workforces are much younger in many parts of the world, we are trying to become more regionally self-sufficient, so we don't do what we used to do, which is take our U.S. business leaders and plunk them in and have them, run the country. So we're trying to grow talent more in the regions. And how do you translate and build on the culture that has really done so well by the company for all this time? And so we've done a few things. One is, and Ivan talked about this if you saw him on the panel this morning, this tone in the middle work. So we take all the corporate communications we do, but then we really work with the local teams to get local faces and local language. So not just that we translate the U.S. versions into a local language, but we'll go get leaders from the U.S. to do the video, from the country to do the videos instead of just putting subtitles at the bottom. We'll customize the message based on input from local teams. So we're really building relevance. We're taking it's one 3M, it's one code of conduct, but we're trying to make it relevant, but by speaking through the local teams, not by speaking through headquarters. We're also doing more and more onboarding with people that are going into critical leadership roles. So for us, a country business leader is someone who's the front end leader in a country for a business, and they can be our best heroes for compliance or our weakest link, right? Because they're the front end, they're with the customer, they're with the channel partners. And every time a new CBL is appointed, we want to get into a rhythm where we're sitting down with them and we're making sure they know their compliance resources and what to do. So really going after those key positions. And then the third thing I'd say is using investigations, again, as lessons learned. So, when you're done, we have a discipline calibration process, so we're trying to use the same factors everywhere in the world to decide, in general, what approach to take to discipline, of course informed by local standards. How are we going to communicate the outcome of this investigation? Mm-hmm. And then even if we don't substantiate issues, our team always is making recommendations for improvements coming up. We didn't substantiate conflict of interest in this case, but we did detect a lack of awareness about X, Y, Z. So really using kind of this continuous improvement approach, so it's not just the online, it's very specific and relevant to something the country has gone through. But it's an everyday, as you know, it's a keep engaging, keep finding new things to do. So.
So I have very little to add to those two fantastic answers. I mean, I guess the one thing I would say is, when you do go out to other countries, it's really important that you have more of a conversation than a training exercise with people. And you do, talk to them about scenarios and mostly try to find out what's on their mind and talk to them and turn that into a conversation about, why all of this is relevant to the company's business and how doing things the wrong way ultimately leads to a violation of the trust that we have with the people who need to trust us. But I completely agree with everything everyone else said.
Great. Well, thank you. We are an interactive panel today, so and we do have time for some questions. So, yes, sir.
Yeah, maybe not as much as a question, but as a European perspective, throwing that in the ring here. Being a compliance council in the EMEA region for T-connectivity, what I see as an issue, what also colleagues of mine that work in global organizations and with American organizations or American management have to struggle with is an expectation management and cross-border investigations. So, as you say, of course, it's not the right approach to just take data privacy as a blank excuse to deny any kind of investigations or data material research. But on the other hand, there has to be a reasonableness about the tools that we actually use in the investigation. And it is often my job to mediate between the different systems and to actually say, look, we cannot use the same approach to investigate a corruption allegation as opposed to a harassment case. We have different means and we have to find appropriate ways of addressing that. And that's much more a cultural and ethical question sometimes where you actually have to find out what's important in the country that you're working with. So when I start with throwing in a European perspective, there is no European perspective. There is different countries that have different laws. And even I, as a European, struggle if I have to judge on what is the right thing to do in Spain or in another country where I'm not that familiar. So I think that's what everyone needs to understand, being involved in cross-border investigation. That is always a dialogue that you have to find an appropriate common ground where you operate and what makes sense. So
And it's different. It can be different in
absolutely.
all over the world. It can be different, right? Yeah.
Yes, sir.
I'd like to ask the representative from 3M, as a physician, neurosurgeon, and an executive from the executive suite, and being across industries as you are, do you have issues specifically with healthcare issues in ethics and compliance in general as well as transnationally?
So healthcare, one of the biggest challenges of doing compliance at 3M actually is the number of different businesses we're in, right? So we're in everything from sandpaper to things you find in a surgical OR. We do have our healthcare business sector. So the sector has a very robust healthcare specific compliance function within the business, and it's larger than resources I would have, to do healthcare compliance, and more specialized. So people with FDA experience, GMP experience, so people who know how to deal with the KOL issues and the Sunshine Law issues. That's really, they have built, and they plug into us through the Business Conduct Committee, for example, but they've built their own capability because of the unique needs of that. Where my team can get involved is to try to connect that pretty robust capability with what we see in the countries, because often we will see more kind of the frontline day-to-day issues and need to know enough about healthcare to spot when something is beyond just a normal, compliance issue under a general corruption framework, and plug those two things together. So I don't try to become a healthcare compliance professional because that's a thing unto itself. My team knows enough about sponsorships and KOLs and some of the stuff that goes on, in the healthcare space, hopefully to help connect the right people to the right people. That's how we approach it.
Okay, we have time, I think, for one more question. Yes.
There were a few people mentioned this morning regional compliance committees, and I was wondering if your organizations have regional compliance committees, and if so, do they kind of run investigations? Do they weigh in on discipline? And if so, how do you sort of guarantee a sort of a strain of consistency throughout the organization and making sure that what sort of corporate headquarters would think is appropriate is sort of getting into the regions?
So we do have regional compliance committees, and they don't run the investigations. We have an investigations team in the U.S. and regional compliance attorneys in the different regions that run the investigations. I think that one of the benefits of the regional team is that we can feed information to them about what we're finding in the investigations that allows them to think about how to respond to those findings in a way that's specific to the geography. And I think in terms of discipline, it's sort of the same answer. I do believe that the regional compliance committees do get involved in that, but I think ultimately for us, discipline is ultimately the decision of the business, and we do try to ensure some level of consistency. We do that mostly through our compliance team in the United States, which is sometimes recommending discipline, but if they see an outcome that seems inconsistent with other outcomes, they will escalate that issue. But I think the function of the regional compliance committees, frankly, is to focus less on doing investigations than on understanding the learnings from the investigations.
We have the same exact format.
Yeah, so do we.
Right. You have, I guess, before we wrap up, do our panelists have any sort of final thoughts I'd like to share with our audience?
Just thank you for coming.
you.
Thank you. I'll give you my final thoughts, which are to thank deeply our panelists for their sharing with us their thoughtful impressions and what their various organizations and how they deal with these very, very complex issues. I think if there's any takeaway from today, we can have one, maybe two, is that one is it all comes back to culture ultimately, and the sort of frontline issue of exporting a culture of compliance throughout your organizations, and I thought your answers to that were fascinating, so I thank you all for those just personally. And that really, when you're talking about investigations, they're investigations, and the key thing is being armed with the right knowledge of local rules, laws, and issues, so as to best navigate those issues without getting into too much extra trouble. So thank you. Please join me in thanking all of our panelists, and thank all of you for joining us today.